Viewers, greetings of the day. This is Soumitra Lahiri from guide to IBC.com. Supreme Court is already on summer vacation. NCLAT is also going to be on summer vacation starting from June. For the entire month, I suppose it will open sometime in July, early July. Supreme Court will open around 15th of July. So this month weekly video will now it will be difficult since there will be no cases. So this weekly video will not be there. But we'll try to shoot videos in between. That will be more subject oriented on one topic or the other. Today, of course, the video is important because there has been some amendments to CIRP regulations. And there are some important cases that has taken place last week. So we'll cover that. We have some cases today and there'll be a few cases tomorrow, which we'll try to cover in the next week's podcast. With this, we move on to the next part of the video. And you can see the screen of guide to IBC.com. Now, before I move on to cases, it's important that on 26th of May, certain amendments have taken place in insolvency bankruptcy CIRP regulations, which in fact we got the Gazette yesterday only from IBBI, and it's better. It's not. There hasn't been much very radical changes, but some changes are there. It's worthwhile to. It will be worthwhile to show you what changes are there. So let us first. It is the first changes with respect to Regulation 18, which you will find in meetings. Yeah, 18. Now in 18, it says that this new clause has been put in. The committee may, the clause number 5, this is new addition, the committee may direct the resolution professional to invite the providers of interim finance to attend and observe as observers without voting rights. Such meetings of the committee as the committee may decide. That means those who are providing interim finance, they may be called at the meeting of Committee of Creditors and they can see the meeting, but they will not have any voting rights. With regard to, there has been some changes in 36A, 36B, and 38. So let us go to that. In 36A, in sub-regulation 1A, a new clause has come in. The resolution professional may, with the approval of the committee, invite expression of interest for submission of resolution plans for the corporate debtor as a whole or for sale of one or more of the assets of the corporate debtor or for both. See, this you will remember this was in subclause 6A of 36B. Now this has been brought into 36A, so that when a Form G is being published, the resolution professional can mention it is for the whole organization or for one or more assets or both. Now let us go to 36B. 36B, I've already told you that this 6A has been deleted. 6A has been deleted. 6A, which used to mention that if the resolution professional does not receive resolution plan in response of the request under this regulation, he may, with the approval of committee, issue request for resolution plan for sale of one or more assets of the corporate debtor. So this has been taken out and it has been put in 36A, which sounds quite logical. So there is not much change, and there has been the 36B, it has been removed from 36B and put in 36A. In 38, there are some changes. Now, in clause 1B, which said that to the financial creditors, the amount payable under the resolution plan 1B to the financial creditors who have a right to vote under subsection 2 of section 21 and did not vote in favor of the resolution plan shall be paid in priority over the financial creditors who voted in favor of the plan. Now, this plan has been put under inverted commas. So, this plan means resolution plan. Now, there is another provision which is added to subclause B, provided that where a resolution plan provides for payment in stages, the financial creditors who did not vote in favor of the resolution plan shall be paid at least pro rata in priority over the financial creditors who voted in favor of the plan in each stage. So it does not say that dissenting financial creditors will be paid at one go. So in every stage, they will get a priority. So this is a new thing. So it comes. We know that resolution plans come on often RAs do mention that they will pay in stages. So in such case, also if they do, then in such case, the dissenting financial creditors will get priority when they're paid in stages also. In Regulation 39, there has been some changes. Yes. In sub-regulation 2, the resolution professionals shall submit to the committee all resolution plans with the details of non-compliant plans and the following transactions, if any observed, found, and determined by him. Earlier, this was the resolution professionals will submit to the committee all resolution plans, which also mentioned that which comply with the requirements of the code and regulations made thereafter. So, which has been shifted down. So it says that the resolution professional shall submit to the committee all resolution plans along with the details of non-compliant plans and following transactions, if any observed by him. Then it comes 43, 45, etc. Now in 3, sub-regulation 3, in subclause A, it is mentioned that the committee shall evaluate the resolution plans received under sub-regulation 2, which comply with the requirements of the code and regulations made thereunder as per evaluation matrix. So the same thing which was there in 2, it has been brought down to 3. These are the changes. Not much, but these are the changes. Now let us quickly go to the cases, since we are having a little bit of positive time because this video has to be completed within a stipulated time. Now, let us come to section 62, topic 14. What does it say? A plaint cannot be rejected in its entirety merely because one of the prayers or relief sought is illegally untenable, so long other reliefs are maintainable and based on independent cause of action. That means it applies to all the courts. So if you have made a plaint and one of the prayer is not maintainable, legally maintainable, that does not entitle the court to reject the entire plaint. The plaint, if one of the prayers is legally tenable, then the plaint has to be looked into, excluding the portion which is not untenable. This was held in the case of the infra developers versus Mahavir, Lunia, and others. So this is the case. Let us go back to now section 62 only. Now we have seen this is an important case. That is why I have taken it as a topic also. In the interest of justice and in order to avoid future legal complications, Honorable Supreme Court may issue an order of status quo. This happened very recently in the case of JSW Steel Limited versus Sanjay Singhal and others. So in this, considering that you know about, I don't need to, I have already covered the judgment of JSW. That's Bhushan Power, Bhushan Steel. So that has the Supreme Court has accepted a revision petition, and considering the fact that the promoters are trying for liquidation, so the Supreme Court has ordered a stay order, given a stay order, status quo. So, in the interest of justice and to avoid future legal complications. Now, let us quickly go to section 65. This is a case of State Bank of India versus LR Builders. It says that the adjudicating authority is fundamentally required to critically examine the material evidence available and base its findings on issues directly related to the case, especially while holding a party liable under Section 65 of the Code. In this particular case, the adjudicating authority had held that State Bank had violated Section 65 of the Code. And NCLAT had gone through the case details and found that there are various ground realities which NCLT had not considered. And thus the order was set aside. And while doing the process, the courts remarked that it is the duty of the court to it's fundamental duty of the court to critically examine material evidence and then hold. And of course, Section 7, this was case of a corporate guarantor. So we know that corporate guarantee, in the case of a corporate guarantee or personal guarantee, the liability of guarantor is coexistent with the principal borrower. So I'm not going into Section 7. You will find this case in Section 7 as well. Now we come to Regulation 33. This is important. This is actually beneficial for insolvency professionals. This is a case of, I think, yesterday or day before yesterday. He says that if IRP or RP's fees and costs are being disallowed or allowed partially, the adjudicating authority must provide reasons for such disallowance. RP or IRP are professionals. If they are charging, there is a basis of such charges. Now, if the same is being disallowed, the rule of natural justice applies to RPs and IRPs also. And in this case, what happened was IRP had claimed, this company went into, the case was withdrawn under 12A, and RP had claimed, and there was a valid reason. I mean, they had agreed on what expenses and fees are payable. And thereafter, NCLT said that no, pay him 20 lakhs, pay her 20 lakhs. So the RP questioned as to why my fees are being reduced. Now let us come to 12, Regulation 12. It says that anyone can submit claim, which the resolution professional shall proceed to verify and collate the claim in accordance with the law. That means the right, any Tom, Dick, and Harry can submit the claim in the required format. The rejection of claim is altogether different. Admission of claim is altogether different. But submission, everybody has right to submit a claim. So this case is of Soham Coal Private Limited versus Vinod Tarachand Agarwal, in which NCLAT was of the view that the view details that ends of justice can be served by permitting the appellant to file a claim before RP within 2 weeks from today. Resolution professional shall proceed to verify and collate the claim in accordance with the law. So he did not express any opinion on the claim, but said that he has got right to file the claim. Then it is the duty of the RP. Now we come to a very important thing. That is what is sale by as is various basis. Now, in section 31, resolution plan, if you look at topic, take its topic. In the case of a resolution plan, SRA takes assets of corporate debtor on as is various basis. This was decided in the case of Dr. Hema Joshi versus Sri Bhupendra Singh. Now, what is as is various basis? This is extremely, but this case is not exactly of Insolvency Bankruptcy Code, but still then, with respect to, let us come to the case concern. With respect to sale on as is various basis, in terms of legal doctrine of caveat emptor, that is, caveat emptor means buyer beware. It becomes the duty of the buyer to exercise due diligence. So Supreme Court, in the case of KC Ninan versus Kerala Electricity Board, part of the judgment deals with what is sale on as is various basis. So it says that a sale on as is various basis postulates that the purchaser would be acquiring the asset with all its existing rights, obligations, and duties. It says that in terms of legal doctrine of caveat emptor, as I mentioned, caveat emptor, it's a Latin word. The English translation is buyer beware. It becomes duty of the buyer to exercise due diligence. A seller is not obliged, or seller is not under any obligation to disclose patent defects of which buyer has actual or constructive notice in terms of Section 3 of Transfer of Property Act 1882. This case you will also find in Schedule Y of liquidation under Regulation 33, because therein also when auction takes place, it is done on as is various basis. Now, since we have covered this, let us quickly come to section 95. We all know that in Lalit Jain, Supreme Court judgment, it said that with resolution plan being approved, it does not mean that the liability of the personal guarantor is absolved. Now, this case says that there can be no dispute to the above proposition that liability of the guarantor is coextensive with the principal debtor, but effect and consequence of the approval of resolution plan has to be considered and looked into. In this particular case, this was a case of MBL infrastructure, the case between Indian Bank and Anjani Kumar Lakotia. In this case, what happened, the consortium of banks accepted the resolution plan submitted by the SRA, or rather the promoter itself, and they revalued the entire guarantee collateral security being offered and made him execute. The old personal guarantee was cancelled and the new personal guarantee was executed. Now, Indian Bank, which was a dissenting financial creditor, instituted suit under Section 95. The NCLAT held that, no, sorry, this is not admissible because there is a new personal guarantee and the old personal guarantee does not exist anymore. So with this, we quickly wrap up this part of the video and we come to the concluding part. Thank you. I must thank you for watching the video patiently, and I look forward to seeing you again sometime next week. Please share this video with your friends and relatives and who are interested in insolvency bankruptcy code. I'm always there to answer questions. If you have any recommendations, if you want me to cover any topics, please write to me. Make a comment on that, what you want me to explore. And we'll try to improve ourselves. Any difficulty you face in uh, going through the website can also be mentioned so that we can get an opportunity to improve ourselves. Thank you. Bye for now.